How do you trap a doctor during his pretrial deposition in a medical malpractice case? Would you like to learn the answer? Come join me on this walk near the beach as I share with you the answer to that question. Hi, I'm Gerry Oginski. I'm a New York medical malpractice and personal injury attorney. Now, the answer to that question is you don't. You don't trap a doctor during the course of his deposition. Now, is that headline a bait and switch headline? The answer is no, it's not. Because there are many people, many injured victims and many injured patients who bring a lawsuit who basically come right out and say, I want you to nail that doctor. I want you to get him to admit that he screwed up. I want you to get him to do all these following things when you question him during his pretrial deposition, which is really nothing more than a question and answer session given under oath, typically in his attorney's office or over a Zoom video call. That is the mindset of many injured patients. They know that something bad occurred to them. They know that they suffered significant harm and injury as a result of this doctor's carelessness. Now, a medical expert has confirmed that they are correct and accurate in their perception and their thinking. And that is what allowed us to go ahead and go forward with bringing their particular case. So now, during the course of the lawsuit, during the course of your lawsuit, I will have an opportunity to question every doctor, every nurse, anybody who is involved in your particular case. And during that questioning, the defense lawyer will be there with the doctor. There will be a court stenographer there to record all of my questions and all of the doctor's answers. Did you know that the doctor's answers actually represent his sworn testimony? And it carries the same exact weight as if he's testifying in court at trial, in front of a judge, and in front of a jury. It's actually a very important component of your medical malpractice lawsuit. So now, can I go ahead and trap the doctor into answering certain things? The answer is no. I'm not going to trap the doctor. That is not my intention. My goal when questioning the doctor whom you have sued is to learn from him exactly what he did and why. I want to understand what was going on in his mind as he's deciding how to care for you and how to treat you. Now, there are a number of things that I do have to ask the doctor. I have to ask him about his medical knowledge. I have to ask him about the standard of care for a patient who presents to his office the way that you did. And I will ask him many, many questions about the standards of care as it existed at the time that he was treating you. I will need to ask the doctor about his opinions. Now, I don't come right out and say, Doctor, did you screw up? Because you know what would happen in that instance? The doctor's going to get all defensive and he's going to deny and he's going to say, absolutely not, I did nothing wrong. Now, he's already said that through his attorney in responsive pleadings. What does that mean? It means that when we started your lawsuit, the doctor had to answer the allegations, and he did that through his attorney. And he did that in a document called an answer. And that answer basically said, listen, I don't understand why you're suing me. I did absolutely nothing wrong. Then he says, you know what? If I did something wrong, so did you, Mr. Patient. Then he says, you know what? If I did something wrong, whatever I did not cause you harm and injury. And then he says, you know what? If I did something wrong and I caused you harm and injury, guess what? Your injuries really are not as bad as you claim them to be. So those are the typical defenses we see in these medical malpractice cases. So now, getting back to the deposition, one of my goals is to ask the doctor opinion questions. And there are different strategies to try and get the doctor to admit that if certain things had been done as we claim they should have been, then your outcome would have been different. Then your injuries would not have existed, or they might be lessened. Now, is it possible to get the doctor to admit those things? It is possible, but it has to be done very carefully and not through trickery. Because the moment I try and trick the doctor into answering a question or ask the doctor a trick question, you know what's going to happen? His attorney is going to yell out, objection! I direct my client not to answer that question. The doctor is very sophisticated. His attorney is very sophisticated and, in all likelihood, very experienced. There is no trickery that goes on during a deposition. There are simple questions and answers. Now, I'm going to ask the doctor a series of hypothetical questions. And these hypothetical questions are based upon the facts of this particular case as we believe them to be true. I know that the doctor disagrees with many of the facts that we argue, and that's perfectly okay, and he's entitled to have that opinion. Now, doctor, I also want you to assume that my client complained of the following things. Would you agree in that instance that good medical practice requires that you do the following tests? And he's going to say yes, of course. Now, doctor, assuming that those test results revealed A, B, and C, and revealed E, F, and G, would you agree that good medical practice required that you do the following things? And now he's going to give me his opinion about what should be done if the results were positive or negative for each particular factor. My goal here is to have the doctor explain in his own words exactly what the standard of care is. I want him to explain to me exactly what he would have done if certain things had been done but were not. And importantly, I want him to explain to me how my client's injuries or damages would be different if those things had occurred. Now, the defense attorney might argue with me about some of the facts that we claim to be true, and that's perfectly okay. But assuming, for purposes of my question, that those facts are true, the doctor has to go ahead and answer that question. Now, sometimes the doctor will simply come out and say, I have no opinion about that. And you know what? That can work. That can work for me. Why? Because it locks the doctor into an answer of being unknown. He doesn't know what would happen. He doesn't know what he would have done. He doesn't know what the outcome would have been. And that's okay, because if and when your case goes to trial, and now I ask him the same exact question in front of the jury. Remember, the jury knows none of what went on during this pretrial question and answer session. The doctor will then have to conform and admit and keep his answer the same as it was when I questioned him a year or so earlier during this pretrial deposition. If he alters or changes his opinion at that point, he can use the doctor's pretrial testimony to show inconsistencies in the doctor's testimony. And then I can explore why his answer is different now at trial compared to a year earlier when I asked him the same question. So why do I share this information with you? I share it with you to open your eyes, to help you understand what really goes on in these medical malpractice cases in New York, where the client, the injured patient, believes that I have the ability somehow to trick a doctor, a sophisticated physician with years and years of experience, and his attorney into answering questions as if I'm hypnotizing them. The reality is, that's not what happens. You know, I realize you're watching this video because you have questions or concerns about your own matter. Well, if your matter did happen in New York, and you are thinking about bringing a lawsuit, but haven't done so yet because you still have questions that need to be answered, what I invite you to do is pick up the phone and call me. You know, I answer questions like yours every single day, and I'd love to chat with you. You can reach me at 516-487-8207 or by email at Gerry, Gerry, at Oginski-law.com. That's it for today's video. I'm Gerry Oginski. Have a wonderful day.